tour. This is the agenda that we'd like to go through for today. Just discussing what IP is, what the main protections are, what the importance of it is, how to protect your business and your assets. If you're a startup or just starting out, or if you're looking to scale your business, how intellectual property can make or break your business. Some interesting case law that might be relevant to you, and then some tips on best practices. So just getting started on what intellectual property is, it's a collective term for creations of the mind and fixed formats in which they can be protected. So at the top, we've got patents, trademarks, and registered designs. These are types of marks that you can actually register protections for. In the UK, that's through the Intellectual Property Office, the UKIPO. And underneath, you have copyright, unregistered design rights, and trade secrets. As we'll get into, these are the type of IP that you don't register protections for, but they are existing. So there are other ways that you can try to protect them. Starting off with patents. Patents protect new inventions and technical functions. So that's the criteria. They have to be new, they have to be an invention, they have to have a technical effect. The patents, once registered, they can last for 20 years from the date of the registration, subject to renewal fees every 5 years. So that is filed with UKIPO. It is a very lengthy process, so we always recommend getting professional advice whenever you're looking to file an application for a patent. The actual timeline for that could take 3 to 4 years because there are various stages that it goes through once you actually file the application. It's examined really thoroughly by UKIPO. There is some back and forth in drafts and research examiners. So it is a very lengthy process, which is why you want to do it if you do have something that you think is patentable, to do it to begin the process as quickly as possible, because it will take some time. In terms of the due diligence requirements for that, it is very important to keep your inventions confidential. In the UK, if you do disclose your invention, you won't be able to get it patented because of that. It does vary in different countries, but that's kind of the standard in the UK. In the EU, there's some exceptions, like the US and Japan, where you can actually disclose for testing the market, but it's, there's strict requirements about that too. So the best practice is to keep confidential until you filed your patent application. So how does that work in practice? If you're a business and you're looking to work with third parties, your best protection is going to be non-disclosure agreements, confidentiality agreements, to make sure that your invention and your ideas are going to be protected while you're going through this patent application process, especially. So in terms of another due diligence is doing your research beforehand, looking to make sure that there's no existing or similar inventions already out there, whether it's in the UK or elsewhere, because you might be looking to expand outside of the UK. So you're doing your searches beforehand and also getting some legal advice, and your professionals can actually help you with that search, because it can be very technical. It's going to be your best bet. So trademarks, those are a little bit simpler than patents. It is generally a faster process in the UK. Trademarks, they protect the sign and the names that are used to distinguish the goods and services of your business from another. So it really is about the branding of your company. Things that can be registered, we've given some examples here. So the name of your business, slogans, logos. I always recommend to my clients that as a base minimum, get your name of the business and your logo trademark protected, because those are going to be, once you start your business, those are the things that are going to be out there in public. And it is a first to file system. So you could be using your business name. If you don't file a trademark registration and somebody else starts using it and files it before you, it's a first to file system. So you run the risk of losing your priority there. So trademarks, there's certain qualifications for trademarks, because they need to be they need to distinguish the goods and services that you provide as a business. So there are certain things that when you're looking to file, you have to bear in mind when you're making the application. Trademarks can't use offensive language, for example. It can't use descriptive language. So if you were, if in example here, you have the Toblerone, if you just put like triangle chocolate, that wouldn't work because you're describing what it is rather than it being your brand. You also can't use laudatory terminology, and that's basically words that are used to puff up a brand. So something like 100% or super, those are going to be kind of terms that that the UKIP is not going to be looking as protectable. You also can't have descriptive terminology in your name, and you can't protect emblems. So it is really good to get some advice on the marks that you have before making the application, to get advice on whether you're going to run any issues in terms of whether it's approved by UKIPO, because once you do file an application with UKIPO, if it's refused, you do lose those fees. In terms of application fees for trademarks, it's pretty accessible. It's £170 for an application, and that includes one class. So when you're making an application for trademarks, there's a whole list of goods and services that are out there, the different classes, and you have to pick which classes that you're looking for protection under. So it is good to get advice on that, because sometimes you might pick only one class when really your business falls under multiple classes, and you want to make sure that you've ticked off all the classes, because once you file your application, you can't amend it, you can't change the classes, you can't change the mark. So if you're under protected, you then have to file another application. So good to get comprehensive advice on which classes you want to get protections under. And then in terms of the process, you file the application, UKIPO then publishes that for 2 months, and that gives an opportunity for any third party to oppose the application. So if they find that their mark, their existing trademark, is similar or identical to yours, they get an opportunity to oppose the application. So it is really important to do your due diligence before applications, making your searches to see if there's any similar marks out there. UKIPO does have a search function on their website, but it is good to get, somewhat a professional to look into these clearance searches to make sure there's no similar marks out there, because at that point, if you do get your application opposed, you have to go down the route of opposition proceedings, which is lengthy and costly, and not something that you want to have to deal with. So it's best to do those searches, make sure you're clear on that there are no similar marks out there, and that way your trademark can be filed and accepted within the 2-month window, which is relatively quick because some countries are different. For example, in Brazil, it could take up to 4 years. So it depends where you want to file. Something to bear in mind is that with these registered marks, it's territorial. So you would file in the UK, in the UKIPO office, and that's getting you protection for your marks in the UK. If you wanted to then expand your business, for example, and go to EU, US, you have to file separate applications for that. There is an international application that you can use for to kind of quicken the process, and it's more cost effective. That is something that is available through the World Intellectual Property Office. So that is basically you'll file your trademark first in one country, and then that gives you 6 months to file an international application to get the same protections elsewhere. So something to bear in mind, also something to get some advice on depending on the countries that you want to operate in. But that's generally how it works for trademarks. Then if we move on to registered designs.
Sorry, quick question.
Yeah.
We have a question regarding trademarks. Jay wants to ask if do you have to register a trademark separately? For example, a separate trademark for a company name and a logo, or is it all together?
Yeah, good question. Sorry, I haven't seen as they pop up. Feel free to ask questions as we go along, and we'll try to answer them. Otherwise, we'll get to them at the end. But for trademarks, you would file separate applications for your business name and your logo. If you had a logo in different colors, you could do that under one series. So that could be one application, but logo, business name will be two separate applications.
Thank you.
So for registered designs, these protect the overall visual appearance of a product, such as the physical shape, the configuration, so how the different parts are put together, and decoration, so for example, patterns on a fabric. They can last for 25 years from the date of registration, subject to renewal fees every 5 years. By comparison, trademarks actually are can be filed indefinitely, so long as you are actually using the mark. So with the registered designs, that's 25 years, and registered designs can be a little tricky because there are certain things that, you know, they don't protect. So they don't protect how the product functions, how it's manufactured, what material it's made from, and the form dictated by its function, which generally means, like, if it's something universal, like a key, you can't register a patent for register a design for keys, because they're kind of standardized. So there are some examples here of different products that would qualify, like the Alexa design or Chanel purse. So you can, so registered designs, you file with UKIPO as well. Application is around, if you do it online, £50 for an application, and then £40 for each additional design. So it is accessible for people to do. And this is kind of in contrast to unregistered designs, which are basically, in the UK, registered designs are not monopolistic rights, which means that you have the right to stop anybody using it. In contrast, with unregistered designs, it's kind of like copyright in that it's not, it doesn't come into effect until someone's copied it. So it gives you the right to claim infringement, but it doesn't give you the right to enforce at the beginning. So both registered designs and unregistered designs are distinct but complementary, and it's good to have protections in place for unregistered designs in more commercial documents, which we'll get onto with copyright in a moment. So there's no formal registration procedure for unregistered designs in the UK. It's the right that is inherent with the creation of the design itself. And that's similar to copyrights, as we'll get onto. So with copyright, these protect the literary, dramatic, musical, and artistic works, such as books, music, art, paintings, films, sound recordings. What's important to know about copyright is that it protects the expression of an idea, not the idea itself. So it's that, you know, example of that artistic expression that becomes protectable. In the UK, there's no register for copyright protection. In contrast, in the US, for example, they have a copyright register, and artists have to register a work, or creators have to register their work in order to then be able to bring copyright infringement proceedings. So that's not a requirement here in the UK, there's no register. But similar to unregistered designs, it's an inherent right. So as a creator, once you've created something, you hold that copyright in the work. In terms of how long you hold that right, if it's literary works, films, artistic works, and music, you have the copyright for your whole life, and then plus 70 years after your death. So your estate would then get the copyrights. TV and radio broadcast, by contrast, is 50 years, and published editions is 25 years. So what copyrights don't protect are works in the public domain. So often works that have actually expired their copyright timeline are then become in the public domain. Single words, facts, and as I said, ideas, not themselves. It has to be the expression that's protected. and titles. So for example, the Countess of, or the Duchess of Cambridge wouldn't be something that you could get copyright protection for. What's important to note in the UK, you have this inherent copyright. So if someone uses your image or reproduces it without your consent, that's considered copyright infringement. And the way you would enforce that is through legal proceedings. But there are exceptions where the use of that image are permitted. So the Copyright Act has permitted uses that are allowed for people. So for example, in study and research, if I'm using an image in this webinar, for example, that's a permitted use. I don't have to seek the permission because I'm using it for educational purposes. Other examples would be news and reporting, journalists that are using images. If there's criticism or parody, so if they're using the image to make a commentary on it, those are permitted uses. It's a definite finite list in the Act, so you have to actually fall under one of those exceptions, and that if it did go to a court, the court would look at, you know, whether you fell under one of these exceptions, and that would be considered fair dealing of the image. And that's not to be confused with fair use. That's a term in the US that they use. They don't, you know, they have fair use exception, which basically has meant through case law that if they take an image and they transform it enough, that's a fair use of it. That type of transformative test isn't something that exists in the UK. So you just want to be careful that, and there's been a lot of case law out there with, you know, Andy Warhol and things like that. So some people think, oh, if I change the image enough, it's fine. Not quite the same here in the UK. So something to bear in mind. So just on one last point on the copyright, you know, best practices for managing copyright of your work would be to record, you know, the creations that or the artwork or anything that you've made. Keep proof of that. So, you know, if whether it's keeping drafts of your sketches or your emails, it's basically keeping documentation of the proof that you created this work. That will help for you to prove, if you at some point need to prove that it's your work or that you created it first because someone else is copying it. The documentation that you keep on that is going to be good for you to be able to prove that. So do record any contemporaneous notes that you have on the creation of that work. Also use contracts. So we'll get into that a little bit in a moment, but if you're working with, as a business, if you're working with third parties, you know, you'll want to make sure that you have the right contracts in place that protect the copyrights and any other IP to your business. And then consider, you know, licensing opportunities. So if you want to allow certain people to use your image, you would have a licensing agreement in place, and you can consider having a fee for the use of that image. So, you know, you can actually generate revenue from that work. So best practices to keep in mind for copyrights. And then we have trade secrets. So this is the most intangible of intangible assets. That's because they're not easy to categorize. Trade secrets include any information that has an economic value, kept confidential and protected through proper measures. They're not easy to categorize, as I said. They result from a combination of different types of technical and commercial information. So here we have some examples of, you know, technical secrets and commercial secrets that might be included. So they protect the expression of ideas, really, and that's what gives your business a competitive advantage. So for technical secrets, that could be things related to your product, their technical features, how they function, new interfaces, especially with software development, you know, that often becomes an issue, how your software program works as well. And then there's other valuable, that's more the technical side, but then there's valuable information to your business in terms of commercial value, so the customer list, supplier lists, pricing, rankings and quality of suppliers. These are all things that, could give your business a competitive advantage. And so they could be trade secrets, provided that, they are being kept confidential beforehand. So it is good to get some advice on the trade secrets element, because that sometimes can be hard to identify.
Thank you, Margarita. So now that we've covered all the different types of IP, could you just tell us why it is important for businesses to protect their intellectual property?
So we've set some points out here, as you can see, as we talked about the different types of intellectual property, it kind of goes hand in hand that in protecting it's going to be really important. So protecting IP enables business to safeguard its ideas, inventions, brands, and creative freedom from exploitation. It's also, and we see this time and time again with our clients, that it's really important for investors. Investors want to see that you as a business have looked into protecting your IP, because it's basically it holds so much value to your business, especially with tech. Trying to avoid having other people come up with, investors basically want to make sure that there's no one else that's going to come up with a similar idea if they're going to invest this money in your business. Likewise, you might have investors that come in because you're selling your business, so they are also going to be looking to what exactly does your business hold in its IP. So really important from an investment perspective. It also just mitigates your risks. People don't like to think about things going wrong or someone copying it, but the reality is we live in a society where, especially with the development of AI, things can be copied in the blink of an eye. So the likeliness of it happening is very more likely than you might think. So it's good to mitigate those risks, because you don't want to have to be embroiled in litigation. It is really costly and stressful. So it's generally just a way to protect your business, but also serves as the foundation for it so that it can thrive, and then you can focus more on the innovations, the creations, the investment, and not have to worry about the legalities or things going wrong. As I mentioned earlier, with IP, the registered ones that you do, it is territorial, and it's first to file process. So just kind of, you want to get some advice on what the IP rules and regulations are elsewhere if you're looking to have a business that expands, and just management of your IP is crucial internally, so that you're, one, you know what IP you hold, and two, whether it's protected. So those are really important things to keep in mind. And then considering that, how do you then apply that? How do you use that? We all can agree that IP is important. So how do you protect your business IP? This is kind of our best practice stages of implementing and protecting IP that we always recommend to our clients. So, as a stage one, you're going to want to conduct an IP audit that's basically looking to your business and identifying where the IP is. That can be hard to identify. Sometimes you might not actually know how far reaching it goes. So it is good to get some external advice on that. For example, you might not realize that the developer that you hired to create your website has, that website it is your IP. And if the contract you had with them gave them all the rights to that IP, then they could basically go on and make similar websites. So things like that, you just need to look at not just what your product is, but what have you done with your product, and where could there possibly be IP with third parties that you've interacted with, making a list of that so that you're aware of what exists and who actually owns it. And then once you have that proper IP audit, then it's good to stage 2 and stage 3 are kind of, they work in tandem. on the one hand, you're going to want to look to the registered protections that we talked about with, patents, trademarks, and registered designs. So getting those applications in early is going to be great. And then while that's alongside that, you're going to look to agreements. So, and that often will help offset the time that it takes to get registered protections, but also for all those IP that you can't actually register protections for, like copyrights. So your agreements, you want to make sure that you have agreements in place with anybody that you're dealing with your business. Sometimes people get into business with a friend, they're co-founders, and they don't really, think about that. But if anything does go wrong, you need to have clear parameters as to who owns the IP. So if you're working with suppliers, contractors, manufacturers, anybody really, you're going to want to make sure that you have an agreement in place, and don't just take an agreement at face value. We see this a lot. People just are given a contract and then they sign it. To get some advice on what you're signing, because lawyers can negotiate those terms. For example, if we see that an IP clause is really onerous to you and is granting it more to the other side, then we come in and we negotiate those terms so that you're not signing away your IP rights unknowingly. And then you're also going to want to look internally. You might be a startup, but you might already have an employee or contractors that you're working, subcontractors you're working with, and you want to have policies in place for any employees or people that you're working with, so that everyone understands the importance of protecting the IP, what it is, what the confidentiality requirements are of your business, so that you can prevent any unauthorized use of business assets down the road. And then once you have those kind of checks and balances in place, stage 4 is just monitoring and enforcement. So, laws can change, requirements for registrations can change. You want to make sure you have, proper calendar reminders, especially for any registered protections, so that you're not missing any deadlines and losing any protections. And then you want to keep reviewing any internal policies as well to make sure they're still relevant. Your own intellectual property may have grown or may have changed, and there may need updating. So always good to keep regular checks on that.
Thank you. Hopefully you've all found useful. Margarita, can you now just tell us how IP can either make or break a startup?
Yeah, I think kind of self-explanatory now that we've seen all the things but basically, obviously it will help make your startup if you are looking at and considering these things from the beginning. So I always tell clients that, it's never too early to start thinking about your IP, how to protect it, and start doing that. Essentially, the moment you have your business incorporated, for example, start looking to getting all those protections in place. It does give you a competitive advantage to have them, and it gives you a strong foundation for growth, because the last thing you want is to, not your business actually does start doing well down the road, and then you're trying to backtrack and look to I've seen that before, where there was no agreement in place, let's say, and then you're trying to get your IP from contractors who believe it's theirs, and then that there's a whole battle there. So really good foundation for your business. And as I said, investors love to see IP protections that are in place. They're going to always do their due diligence checks on your business before investing. So they're going to want to see who owns what, and what the actual what's out there in the market as well, to see how your business is unique, because they're not going to want to invest in something that's generic. So it will also, as a startup, it'll help leverage your IP assets. IP protections can help you leverage your assets basically. So you can generate revenue through your IP, whether that's through licensing agreements, like I said, with copyright, if you wanted to license it out so that allows other people to use it at a fee, and then that's regular, income for your business. Franchising or outright selling your IP. You want to be really careful with any selling of IP because that just transfers the right altogether. But if that's something that you want to do, then you get the right agreement in place, and that could be a great monetary benefit to you. And then IP rights to give startups, the legal standing if they have to go to litigation. You might not want to bring proceedings against someone for infringement, but you might, without your knowledge or desire, be the recipient of it. And on the defense side, someone might believe that they hold priority in, pursuing you for infringement. So it gives you the proper, foundation to defend yourself from any competitors who think, that they try to either attempt to infringe your IP or brand identity. So it is really good to consider. It will give you your business kind of some, confidence. It'll give you confidence, and it'll give your investors confidence. IP really does support innovation, and that drives economic growth. So can't be stressed enough how important it is. In terms of breaking a startup, I think that's self-explanatory. If you don't have it in place, the two main issues that we see are on the investment side. Investors are hesitant to invest with startups that don't have the right IP in place. Logically, they'll see it as a risky investment because then other businesses, it can be replicated. It might already be out there. So if you're looking to grow your business or get the right investment, definitely have those protections in place. And similarly, another issue is the legal battles that that you could face if you don't have them in place. There's just a lot of financial drain that can come from it. So whether it's through the trademark process or copyright claims, there's a lot of litigation already out there. So it's good to just avoid that from the beginning.
So as Margarita has hinted, a lot of companies have found themselves involved in litigation when it comes to IP protections. So two of the main cases that we'll be going through is McDonald's and Supermac's case, as well as Match Group and Mismatch. So we'll just give you a little summary of both cases.
Yeah, we thought these would be interesting because they're trademark cases, and usually I've seen a lot of people who will file their own trademark application because they think it's a quick and easy process, but there are certain requirements that you have to meet. So these cases kind of show the issues that can arise if you don't have those checks and searches done before. So in this case, Supermac, which was it's an Irish restaurant chain from like the 1970s. They were trying to file an EU trademark for Supermac's, the word, and then McDonald's opposed it. So like I said, there's that 2-month window. So McDonald's came in, said, no, it's too similar to our trademark of Big Mac. So that when you're looking at opposition proceedings, the test is whether it's going to cause a likelihood of confusion with consumers. So McDonald's was saying, yes, it's going to cause confusion with consumers. Supermac, as a counter to that, made an application to revoke the EU trademark of McDonald's. So that is a process that could happen. And when I was saying that trademarks can be protected indefinitely if it's in use, that's kind of what I mean. So if your mark is not being used in a jurisdiction, then another company can make an application to have that trademark revoked, and then you have to prove that you are using it. So that's what happened here. McDonald's filed evidence showing like, no, we're using it in the EU, but they actually lost in the first instance. And then they appealed it. Eventually, they did win. But what happened was they had to basically stop using the mark from the point of that first decision, 2017 to 2022. while this was going underway. So always really important to use your trademark if you're going to file an application for it, and to make sure that you're aware of any similar marks out there that might pop up to say that there would be a confusion to the market or not. And then another case we had was Match Group versus Match. So Match Group is online dating services. They've been around, I think, since the 90s in the US, then 2001 in the UK. And Match also offered online dating services, but to the Muslim community specifically, and that was since 2011. Interestingly, they were actually in negotiations. Match was going to acquire Match, but then negotiations fell through, and instead they sued them for trademark infringement. So that didn't end well for them. Basically, they said that they were going to, the use of Match was an infringement of their trademark, and that even though it was Match was the dominant part of the mark, and so that was going to confuse the public. Interestingly, they argued that it was going to be an indirect confusion to the community, which basically means even if there's no direct confusion of the two marks themselves, there would have been a confusion in that the community would have thought that Match was part of Match. So their association between the two businesses was going to be confusing, and so there was an indirect confusion there. And the court ended up upholding that argument and agreed. So Match won on that front. An interesting point on this case was that the Match was saying that their defense to the use of it was honest concurrent use. So basically saying they were using the mark honestly, they weren't trying to take advantage of the mark for, or work or get work off the back end of the other mark. So that is a defense, but the court held that it's not a standard defense. So basically that means even if you're using the mark honestly, you have to then show as a defendant that the other side wasn't adversely affected by it. And because they didn't do that, they didn't win on that defense. So just something to bear in mind when you're using, marks that yourself as well. So when you're doing that search beforehand to see if there's any similar marks, you want to make sure that you're not, even if you're using it and you think it's, different, it's good to get some advice on that to make sure that a court wouldn't disagree on that.
So just to summarize now, we've created sort of 6 top tips for best practice in IP. So we're just going to go through those before we proceed to questions, because I can see we've got a few waiting in the chat.
So kind of what we've gone through before, we're just trying to make them a little more succinct. Best practice 1 is doing that audit of all the IP, as I mentioned. You might think that you don't have any IP, but just do your deep dive, because you never really know. Look at any conflicts that you have or that you might want to have. And then off at the end of that, make sure you do have the right, documents and contracts in place with any third parties. Make sure that you have the right registrations in place for any IP that you can register with UKIPO. And then, as I was saying earlier, start as early as you can. It's never too soon, and it's a first to file system, so the earlier you get in there, the better. Then international protections, consider what you want to do with your business. Is this going to be something in the UK only, or is it going to, do you want to, expand internationally, and then get, a sense of what those requirements are in other jurisdictions to ensure that you're then going to be able to protect your IP there. You also want to make sure that, you're not exposed to any potential. There might be an international company based elsewhere, but also protected in the UK. So you just want to make sure you have a full international view of things and not just thinking isolated in the UK. because we are an international world, and even if we don't intend, it can overlap. And then, as I said, monitor and enforce, just making sure that you are making sure that you have the IP protections contractually and with your registered protections, and looking to internal policies and making sure they're up to date with any changes and any calendar deadlines that you need to keep track of, and training. So looking to your internally, any employees, making sure that everybody's on the same page as to what the business IP is, how they can use it, how they can't use it, so that there's no issues that arise in the future. And just generally, the quick tips I would think of is, make sure you know what your own IP is. Make sure that if you're hiring third parties, that you yourself don't have any counterfeit products that are unknowingly being used. If you're going to use images online, make sure you have the right permissions if you need them, because you don't want to have to deal with anything on your end either. So it's just a matter of, you want to protect your own IP, but you also want to respect other people's IP. And that's going to be through, constant due diligence, and do get some professional advice if you have any questions on that, because it can get really technical.
Okay.